My name is attorney Howard Ankin, and I've been practicing workers' compensation on behalf of petitioners for the past 26 plus years. Today's topic is how to evaluate permanency in a claim. Typically, permanency is under Section 8E or Section 8D. 8D would be as a man as a whole. Section 8E is for an itemized body part. If you look at the Act, various body parts under Section 8E are itemized. Accordingly, you may have a foot be worth one rate, an eye may be worth another rate, or a leg may be worth a certain number of weeks. You would take the percentage of loss to that body part, or under Section 8D for a man as a whole, which is 500 weeks. You would take a percentage of disability or recovery to that body part, and that would be multiplied by the PPD rate, the permanent partial disability rate, which is 60% of the average weekly wage. Calculating average weekly wage would be a topic for a different video. In terms of calculating permanency, the question is how do we determine how many weeks loss of use of a body part somebody has? Historically, you could go to a QDEX, QDEX, or a settlement guide, which shows all the cases that have been tried in a specific year in the state of Illinois, or more specifically for the Chicago call, all the decisions of an arbitrator on that call to understand how to arrive at a specific case value. Historically, since workers' compensation has been around for a long, long time, there are specific values for certain types of cases. So a certain type of shoulder injury, a certain type of knee operation, a certain type of back operation, all has somewhat a defined value. A lot of times by just showing up to the commission and asking fellow workers either on the petitioner side or the respondent side, you can easily ask people what they feel a value of a case is by letting them know what the facts of your case are. People will give you a pretty good guide about what the value of the claim is. Also, if you're unsure or if you feel you have an exotic situation that is unlike anybody else's claim, you can ask the respondent if they would pre-try the case with the arbitrator. The arbitrator would listen to the facts, and the arbitrator would give you an idea of what they would write if they would hear the case, and then you would know a guideline as to what the value of the claim is. For me, the question of how long somebody's off of work for TTD doesn't come into play as much unless you have something like a back sprain, strain, or other type of sprain, strain cases. Then the longer somebody remained off of work, that may come into play to getting additional compensation in the claim. Otherwise, the value of the case is based on strictly what the medical records look like for what this injured worker's value of their claim was at the close of the case. Under 2011 guidelines, there is a section of the new law which allows for an evaluation for an MMI rating to determine or to help determine what the value of the injury is. Typically, in order to have an MMI rating, that is a very expensive process on behalf of the petitioner and could also be very expensive for the respondent. A respondent may want to use the MMI rating if they're trying to bring down the value of the case, then they may want to spend their time and money on that. For the petitioner, typically having an MMI rating is never going to help set the value of the petitioner's recovery any higher. Accordingly, knowing what the customary values of that case are worth, then looking at the age of the injured worker, what type of job they are performing, and more specifically, what the medical records say about that injured worker's injury is going to define what the value of the claim is. If you have an injured worker where you feel very strongly that they're entitled to get additional compensation, you may wish to think about getting some type of expert in order to evaluate the injury in order to increase the value. Same way, respondents typically always have some type of expert look at the claim in order to bring the value of the permanency down. To learn more about the benefits of joining our ISBA Workers' Compensation Law section, please visit the ISBA website. Specifically, you have questions and you'd like some quick answers about valuing permanency, please do not hesitate to contact me. I am attorney Howard Ankin, and I can be reached at 312 600-0000.